Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi weekly, once in 2 weeks, phone call for the community where we try to answer your questions as best as we can, with the caveats that these are not going to be perfect answers in the few minutes that we have. We do the best we can to show you the method and the way that you should proceed forward. And this is not a substitute for a consultation, nor does it establish an attorney-client relationship. We are just giving you information as best as we can. And you would have heard that when you logged in, we have a cautionary statement in the beginning of the phone call. First question, HP211 says H4 to F1 change of status. I'm a little confused about your question, Hardik. I hope you're on the phone because I don't understand your question. I can generically tell you that if an F1 change of status is denied, it should have no impact on an H4. Similarly, if somebody is applying for an F1 visa from outside the United States, which may not be your case, even there, as long as you don't tell a lie or there is a misrepresentation, just because an F1 is denied has zero impact on the H4. I think those are your questions. I can't really tell because maybe I'm just not reading it right. Something is not clear here. If you're on the phone, press *5. Hardik, if you're on the phone, press *5. Maybe you can clarify this for me. Okay. So this is from California. Hardik, go ahead. I can hear you.
Yeah, Rajiv, so the question, you got it right. So my first question was regarding the graduate certificate program. You have
No, I
seen the
saw that. I
graduate
understood.
program,
I
master's
understood
program.
that you go in, you are going in for a
So
diploma.
certificate program
Right.
is
And
the
then
same, like there is no risk of getting F1, right?
I do not know the answer to that question. That depends upon the school. If the program is, if it qualifies as an I-20 issuing program, I don't see why there should be an issue. That's really the school's lookout, not ours.
Okay.
Okay. But the chances of getting an
Yeah.
F1
Yeah.
change of status or visa are the same, in my opinion.
Okay. Okay.
Okay.
That's all. That's all
Good
the
luck, sir.
questions.
Good luck.
Yeah. Thank you.
Mm-hmm.
Thank you.
Okay. Let's go on to the next question. And this is from Wendy. So here the question is, if somebody has an EB1A, which is extraordinary ability alien, but it has been sponsored by the employer and they want to change jobs. For example, they want to start their own business. Is that going to be a problem? Well, yes, I think that should be fine, but I would like this issue to be researched before there is a definitive step, because this is a big step, right? So as I remember the law, without looking into this very minute issue, as I remember the law, for EB1A, portability is not required because an EB1A person can work anywhere as long as they are working in their own area of expertise. So for example, if you have obtained your green card in EB1A through your expertise in Internet of Things, you're an IoT guy, you can definitely get another job in IoT. Can you start your own business? That might have little twists and turns. We want to make sure those are covered. So somebody should look at the latest rulings from various government agencies, including any memos, etc. on this, as well as any decisions on this. But what if we want to go from Internet of Things to, let's say, network design is probably still close enough, but what if you want to go into artificial intelligence, which is definitely quite different from Internet of Things? Can you still carry your EB1A forward? I think that depends upon the focus of the petition that was approved. If the petition was approved more as a technology person and not necessarily as an Internet of Things expert, which I think would be unlikely, things might be different. So this is not an easy answer. Generically, it can be answered. that yes, EB1A can do any work anywhere without a portability, simply because they are allowed to work without a job offer as long as they are working in their own area of expertise. But the problem is, how does it apply to a specific case? That should be researched. I would be irresponsible if I gave you a response without looking at the latest rulings on this subject. Star 5 if you have a follow-up question on this. Star 5. Okay, let's go on to the next question. Executive transfer. I'm on L1A. I have EAD AP with 485 pending, 180 days. To use portability under 221G to switch to another job, do I need to await I-485J approval? No, you do not. You do not. You only need to file, and actually even the filing can be delayed, but in my view it should be filed as quickly as possible. Is there any negative impact on the green card timeline? Normally, no. But look, this is the way I see it. If you're getting a really lucrative offer, do you really care if it takes a couple of months extra? I don't think it should, but it could. It does add a little bit of time. It depends upon how far along in the process are you. If the dates are current and your 485 has already proceeded along various processes and it is quite advanced in its processing, it might delay your process a couple of months, a few months, depends. I can't really answer that question. So the two questions you have, do I have to file and do I have to wait for the supplement J approval? The answer is no. Any negative impact on timelines? Maybe, but practically I don't think it matters that much. Star 5 if you have a follow-up question. Star 5. Okay. Oh, there is a question. Let's see. This one is from New Jersey. New Jersey, go ahead, please.
Regarding the portability, is it required to await I-140 approval before portability? I-140 timeline?
No, I already told you.
Months.
Yeah, I already told you that in the beginning, that you are not required to wait for the supplement J approval. That's not a requirement. So much so, if the supplement J is denied for some reason, we have done so many of these cases, I've never had a denial. But let's say it is denied. You have the option to go back to the old employer or maybe even do another supplement J with another employer. Okay?
Okay, thanks.
You're welcome. So let me make it clear one more time. You can file supplement J anytime and you don't have to wait for the approval to join a new job. Okay? Good luck. All right. Next one is Dreamer001. Got married April 2019. Wife came September. I-140 was approved. Doing H-4EAD. Should we wait 90 days? I don't see why you should wait 90 days. This is a benefit available to H-4 holders. In my opinion, there should not be any 90-day deadline on this. My view, go ahead and apply. I do. Star 5 if you have a follow-up question on this. Star 5. Okay. Next question. So the naturalization was cancelled and you had a period in which you were outside US for more than 6 months. This was way back before 2013. Could that become an issue? Yes, it can, because government can go back and say, well, it looks like in 2013 you abandoned your green card because you were outside USA for more than 6 months. This is not an automatic abandonment, but the burden is on you to prove that you did not abandon your green card. So they can come back and make you prove that, for instance, you didn't quit your job, you didn't take another job in India. I'm assuming you were in India or wherever your home country is, and your family was still living here. Your kids didn't start going to school in India or your home country. So things like that, they look for those things. These days, government has become extremely tough in approving naturalizations. I recently had a case in the Eastern District of Virginia. We're filing another delay case. I'll talk about that in a second. The naturalization had been delayed for 2 years. 2 years. Can you believe that? So when the client came to us, I said, look, we should file a lawsuit. I think that's the way to go. So I filed the lawsuit, got the government served. Within 2 weeks, I heard back from the government saying, if you withdraw the lawsuit, we have to withdraw the lawsuit for technical reasons, because once the naturalization has reached a certain point and we file a lawsuit, then the jurisdiction for adjudicating the application goes to the court. So we withdrew the lawsuit. I knew that they were going to approve it. I suggested to the client we should withdraw it. And within I think about 3 weeks, they had the naturalization approved. So keep in mind that there is always the option, if they try to jerk you around too much, to go to court over these things. Of course, it should be assessed by your lawyers, not just by you. Also be prepared to defend the idea. They may not raise it. There may be other issues in your background. I had another case in which they went back 12 years and they said, well, your employer went to prison because they had lied while you were working for them. Well, it had nothing to do with this gentleman. So even that naturalization we got approved. They came to us after the denial. I filed an appeal. I appeared for the appeal. I argued the matter with the adjudications officer, and the officer said, yeah, it looks like we made a mistake, because he had no involvement in that. You can't hold people responsible by association. Just because your friend went to prison doesn't mean you're guilty. Okay, so I don't know what the background is, but normally when they cancel the naturalization, I always start looking at the case carefully. That means they are doing some kind of an investigation. But if you are otherwise solid, I wouldn't worry about it. *5 if you have a follow-up question. *5. Okay. Next one. This is, I'm on H-1B visa, approved I-140 EB2. I was in the US for 4.5 years, came back to India last month. Current visa is valid till 2020, planning to return January 2020. Can my employer upgrade my process to EB1 category? Or are there any restrictions since I'm on H-1B? There is no restriction. If you qualify for an EB1C, I have another case I think a couple of months back. This one is a local company in Washington, D.C. They have operations in India and they have operations in Washington, D.C. So they transferred one of their managerial level employees for a senior technical job in USA. But when I looked at the case, it was quite obvious that this guy can qualify for EB1C green card. So we got his EB1C green card while he was still on H-1B. So L1A is not a necessary intermediary step to get a green card under EB1C. So the answer is yes, you can file EB1C. In case I want to delay beyond August 2020, do I have to go through the quota? No, you do not. You do not have to go through the quota for the next 6 years, maybe forever, because your I-140 is approved. So 6 years at a minimum, you are fine. Okay. *5 if you have a follow-up question. If you're here, *5. Okay. Maybe we should start doing these calls on a weekend. People might have difficulty logging in because they are at work. Okay, Nisarg says, I have applied family-based 485, 761, 65, 131. Can we expedite due to financial hardship? Oh, yes, you can. You can. You can certainly try. If there is financial hardship, do me a favor. Just do a Google or search engine search for the words USCIS expedite criteria. USCIS expedite criteria. I think there's 6 or 7 of them, and you can see which one you qualify under. It's certainly worth trying. *5 if you have a follow-up question. Okay. Let's get you on the phone. Yeah, go ahead, please, Nisargji. I can hear you.
Yeah. Hello, Rajiv sir. So I applied my EAD in February 2019.
Yeah, I have all those
February.
facts. Yeah, I have all those facts.
Yeah.
I understand.
And it's been more than 8 months. I don't know why it's getting delayed. So I'm a little bit frustrated.
No.
And my next question is Sorry.
Yeah, I had a third question that I wanted to answer, which was still remaining. Can I file H-1B again if H-1B has been denied during my 240-day period? The answer is you can apply anytime, but you will not be able to get change of status within USA. So unless you apply or extension, if you apply within the life of the existing I-94 and status, only then you can get within USA. Otherwise, you have to go outside for visa stamping. And also be mindful of the unlawful
Okay.
presence, which begins the date your timely filed extension is denied. So be careful with that.
Okay.
180 days of that can become a problem, but theoretically anything can be done. And if you do premium processing, that will give you the the room to be able to get an approval or at least a decision within the 180-day period. I don't recommend people stay back, but your lawyer should discuss that with you. Um, Applying again is not a problem. Getting it within USA is a problem. But go ahead. You had something else.
Okay. I mean, so I'm on 485 waiting status, pending status.
Mhm.
So on that basis, can I apply H-1B? Is it advisable?
Well, you see, the thing is, when you have a 485 pending, I have discussed this in great detail, this issue of what is status, what is authorized period of stay, what is unlawful presence, what is out of status. These are all different concepts. So when you are on 485,
Right.
you cannot convert from 485 to H-1B. You have to go outside for visa stamping.
Okay.
Okay.
Got
But
it.
you can certainly use your EAD. Why not? I would.
Okay.
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 And you can apply
All right.
for an
Yeah. Okay.
H-1B,
Thanks.
Nisargji. You can apply for your H-1B.
Okay.
Just keep it in your back pocket. Go for stamping whenever you have time.
Yeah. Sure.
When you come
Okay.
back using your H-1B visa, you're back on H-1B, no longer on EAD.
Okay.
All right.
Got it.
Good luck.
Thank you.
You're
Thank you.
welcome.
Yeah. Thank you.
Okay. Let's go on to the next one. This is Ravik for you. I am on H1. Wife is on H4. H4 EAD. H1 is expiring. Wife's H4 EAD is expiring too. Hers is March. Mine is July of 2020. Extension is pending. My employer will also file H1 H4 EAD sometimes in Jan Feb. I'm not sure if we'll get her H4 EAD on time. Some of the attorneys are suggesting filing lawsuits. Funny you should bring that up. We are filing our first lawsuit on H4 EAD delay next week. So I'll inform you what happens. But the reports that I am getting are basically that once we file the case, because the government has a pretty weak position, once we file the case, they are settling cases, they are approving. So I'll let you know what happens. Ask me maybe in a few weeks. I intend to get the government served case filed next week. I still have some fine tuning to do. We have the draft ready of the complaint. We are filing this case in Washington, D.C. Okay, because remember, no matter where you are located, most times we can file the case in Washington, D.C., which is right next door to us. We are just about 5 miles from the courthouse. The advantage of doing it here is that, no matter where you are located, it can be filed here. The disadvantage is it has to be done a little carefully, because government can come back and they can fight the lawsuit saying you should file it where the person is located or where the application is pending, and the court can transfer the case. It doesn't happen normally because there are sufficient reasons to file the case in Washington, D.C., but just a little bit of a heads up. So yeah, that can be a possibility, but only if your case has been pending X number of months. The question is, when does a lawsuit become possible? I'm not sure I can give you any particular time frame, but I know that my colleagues are filing it after 6 months of pendency. And I think if it's over 6 months your EAD has been pending, go ahead and contact your local lawyers or contact us. We'll be happy to start a lawsuit for you. And we'll see how it goes. So far, it seems to be going okay for most people. Okay? *5 if you have a follow-up question. *5. Okay. So BMAX says, can we have multiple H4 processing in parallel? I think it's a waste of time and money, but yes, there is no limit to how many employers, when they file your H1, can also apply for H4 extension. In fact, that might even be the smart thing to do, because if you have 1, 2, 3 employers and all three of them have not applied for H4, only one has, and let's say you don't join one or you quit one, they would drop the application for the H4 as well. So it makes sense to have, I don't see why not, have multiple employers file. As to the per country S386, I do not know what's going to happen. That's impossible for me to comment. I haven't even put any attention on it, because until it gets passed and has some hope of passing and then getting signed by Trump while that guy Miller is still has his ear, I think that is unlikely in my view. But I don't know. I hope I'm wrong. *5 if you have a follow-up question. *5. Okay. This is Santonio. How long does DNA testing take? Last time we did one was actually quite interesting. It was somebody was in India and their family were in USA. So the way it works is the approved lab does the testing here. Their corresponding India lab does the collection of the sample here. Then the testing is actually done in USA. I think it took about 2 months, if I remember correctly. But that was about a year back. I do not know. I don't have any time frame for this. But you can call the lab also. Let's see what you've done. Your case started in 2014. 2019, husband submitted DNA. This is June. You contacted the AABB. They had not yet received the samples, I guess, from India or wherever you are from. You've been married for 6 years, but together for 10 years, son turned 5. What could be the reason for delay? I don't know the answer to that question. I'm trying to see what is the best way forward for you. I think it's too early for you to file a lawsuit, because the paperwork was only completed in, when was it? DNA was given only in June. So maybe June of next year, you can start thinking along the lines of a lawsuit, maybe a year or so. But in the meantime, have you tried contacting your congressman's office? That would be the way to go. Contact your congressman's office, whether it is the US senator or not the state senator, US senator, or the House of Representative member. Ask for their help. They can cut through a lot of red tape for you. Go ahead and do that. Okay. And it's free. It doesn't cost you anything. *5 if you have a follow-up question on this. *5. All right. Let's go on to the next question. This is SK 1990 H1B transfer. Employer A visa is good till August 2020. I-94 September 2020. Or 10 days plus. Not sure if visa is revoked. Resigned from employer A. Employer B H1 transfer is in process. Working there on receipt. Can employer C file transfer while employer H1B's transfer petition is pending? Absolutely. Absolutely. It's done all the time. Many companies don't want to offer, as they would have to use the petition of employer A and pay stubs of employer B. That's perfectly legal. If the regulations actually provide for it. These are called bridge petitions. It's absolutely perfectly legal, and the regulations provide for it. Look at 8 CFR 214. I think it's 214.2. So look at 8 CFR 8 Code of Federal Regulations, regulation number 214. Under that subsection H, it expressly says you can do this. Multiple transfer petitions can be pending, and you could be working with any one of those transferring cases. There are some other complications, but filing a case is not a problem. Worst case scenario, you have to go outside USA to get visa stamping. Big deal. They asked the question, is my employer A's petition is revoked or still valid, which I don't know. What options do I have? all you can do is contact the USCIS 1-800 number, see if you can get the information from them. Oh yes, absolutely. I would file everything premium processing. And you can have employer B, C, D, E, F, all of them file at the same time. But the way this works is, so let's say you have, first case was employer A. You filed a transfer while you are still working for employer A. Now you are working for employer B who filed the transfer. While you are still working there, C, D, and E, and F, they all file your transfers. You started working for F. So if anybody's petition fails, then you have to go outside USA for visa stamping because they are all depending upon one on the other. So I'm not able to explain that well, but the idea is quite simple. So if you have multiple petitions, each filed successively, each depending upon the previous one's filing for status, if any rung of the bridge fails, you'll have to go outside USA to get H-1B visa stamping. That is all. It is not the end of the world. Okay. *5 if you have a follow-up question. *5. All right. This one is, let's see, from Texas. Texas, I can hear you. Go ahead, please.
Yeah. Should employer C petition be a bridge petition?
See, the way the bridge petitions work is this. So let's say your H-1B with employer A is expiring today. Okay. And let's say employer B filed your extension yesterday. So when they filed it, you were still in good status. Okay. Now, tomorrow, you are no longer in status with employer A. Let's make it even simpler. Let's say employer A also filed an extension for you last week. Okay. Now, you are deriving your status from two places. One, a timely filed extension by employer A and a timely filed transfer from employer B. Right? If you join or if you get a transfer filed by any employer after tomorrow, today your status is expiring. If tomorrow anybody files, then both employer A and employer B's pending cases are your bridge petitions. Why? Because you're deriving your status from them. If employer A revokes your case, you are still okay because employer B had filed a transfer while you were still working for employer A. But if employer B also revokes, then you have to go outside USA for visa stamping because employer C was depending upon the bridge of A and B. Okay.
Okay. So I mean, so as the I-94 is valid, so suppose let's say employer B petition denies, I mean, worst case scenario, come back to employer C or?
You cannot, you have to go outside USA for visa stamping because C was depending, well, actually, no, you're right. You will be okay because employer A's bridge petition is still going on. So you might be able to get status. Now, what sometimes the government does is they will say, we won't approve employer C status because the previous case, which is A, B has been withdrawn and A is still not decided. So until A is decided, we won't give you status on C. We've been able to successfully get these approvals. Worst case scenario, you have to go outside for visa stamping. Okay.
Okay.
Listen to this discussion.
Yeah, a little bit confused.
Yeah, I know it is. Listen to this discussion. Listen to this discussion when you hang up. Understand what I just said. It is not that difficult to follow, but you have to take some time to digest it. If you still have questions, call me back next time. Okay.
Okay. Yeah, can you tell me that section of law that you have mentioned?
8 CFR 214. It's actually available. 8 CFR Code of Federal Regulations. Just type in Google 8 CFR 214.2. Okay.
Okay.
Good luck.
Okay. Thanks a lot, Rajiv.
You're welcome. Bye-bye.
Yeah, thank you.
Okay. Let's go on to... Actually, we are going through questions very quickly today, so that is a good thing. We'll have time to answer new questions. Kumar question number 13 says, Company A filed for my future employment based employment green card, PERM, I-140, EAD advance parole, all done. Okay, I-140 approved in EB2 category. Downgraded this to EB3 and did concurrent filing. I've got EAD and advance parole. Actually working for company B on H1B. Never worked for company A. I want to go to India. I don't have a visa stamping. Can I come back and still be on H1B? The answer is no, I don't think so. Because as I remember, I think it's the regulation or the policy statement that says, if you have an advance parole, you know what? I could be wrong. Because the language of the law is like something like this. The law says, if somebody has an H1B, but they travel using advance parole and come back on advance parole, they are still considered to be on H1B if they go back to work for the same employer who got the H1B approval. So you meet that requirement. The only difference is that the employer who got you your EAD is not the same employer as the employer who you are doing your H1B for. So I think there's a little bit of a gray area here, but the language of the law suggests if you are coming back to work for the same employer, you are considered to be still on H1B, not EAD. Okay, so I hope that makes things a little clearer. One second, I think I forgot to. Somebody has their hand up from Texas. I don't know. I think I forgot to put their hand down. Oh well, I'll get to it in a couple of seconds. So that is the way it is. I think it's a little bit of a gray area. I'm not sure I can give you an answer that is absolutely clear without looking at the entire background of the regulations and the policy. So, but I gave you what kind of the law says. It could go either way. I think you'll be okay. But since you are not working for the same employer, it should be looked at. *5 if you have a follow-up question. *5. Okay. Somebody from Texas had their hand up. This works like a toggle. If you press *5 again, you'll be on because you just went off. You must have pressed *5. If you have a question, press *5. Okay, this is Texas. Yes, Texas, go ahead, please. Texas.
Hey, Rajiv. Yeah, thank you for answering the question.
Right.
So, I mean, I can still be on H1B using the advanced parole of a different employer.
Well, I don't know the answer to that question. I think your lawyer should look at it very carefully. I gave you what the sort of the language of the law says. I'm not sure I can answer that question definitively. Okay.
Okay. So, suppose if I wanted to, I'm trying to understand, like, yeah, if I use advanced parole and then can I use the EAD that I have with a different employer?
Of course. That EAD is good for anything you want to do. Absolutely. So
okay.
even though the EAD
so wait,
was, hang on, even though the EAD was approved through employer A's petition, you can use it for employer B, no problem.
Oh, can I use that EAD approved for employer A to employer B?
Absolutely, yes.
Okay. Even so, my 140 with the employer A is still in pending status. So, do you recommend using the EAD?
That makes things a lot more complicated. Because you're not Kumar, right? You're not the guy who posted this.
Yeah, I'm the guy who posted
But
it.
you say my I-140 from company A is approved.
Approved, but we have downgraded the 140
the EB3
to
one is not approved.
EB3 category.
That's
yes,
an interesting,
EB3 one is
that
not
is an
approved.
interesting issue. I have to think about this. This is quite an interesting issue because portability begins upon the I-140 approval. And that I-140 is connected with the 485. So the portability will not begin based upon the old I-140 approval. My guess would be, again, it's very dangerous to make guesses in law because you can be wrong as often as you're right. My best guess is they're probably going to send you a notice of intent to deny the I-140 because they've been doing that. I've seen other cases, and of course, most of them we have won. They send a notice back saying, it looks like you voted before the I-140 was approved. That means the job offer is no longer valid. Okay. However, we have always resisted that, saying this is a future job. What's your problem? As long as we have a good faith case, usually we win. So the answer is, can you use the EAD? I do not think using the EAD triggers any additional danger for you than you already have. Okay. The danger that you have is that you are not working for the future employer. Okay. But using the EAD does not increase your danger, in my opinion. Make sense?
Okay.
So you can
Sure,
choose
sure.
to,
Got
you
it.
can choose to, but have a discussion with your lawyers. Be prepared to resist a pushback from the government saying that you actually you didn't port out. It was you never actually worked for that employer. They can come back and say, is there a genuine job offer available? So make sure you work that out with your lawyers. Okay.
Okay.
Good luck.
Thank you.
You're welcome. Okay, next question, number 14, MKB3, working on H1B for a consulting company A last 9 years. 2012 green card in EB2 category, I-140 approved in 2013. Is it a good idea to take a full-time job opportunity? Okay, what will be the impact on H1B extensions? Well, I do not know exactly what is going on. I'm assuming you have not filed your 485. You know that you'll have to start your green card all over again, but it will carry the priority date of 2012, even if the old employer withdraws the I-140. That does not affect your priority date, and that does not affect your right to keep extending your H1B beyond 6 years. Your wife's EAD will also continue. It should have no impact, even if the employer withdraws the I-140. In case of layoff, you have 60 days or time remaining on your I-94 to apply for another H1B, whichever is shorter. So if you have 35 days remaining on your I-94, you can only have a grace period of 35 days. If you have 6 months, you have 60-day grace period. So 60 days or I-94, whichever is shorter. Verbal commitment doesn't mean anything. I don't think you can hold your employer to filing your green card. Even if they give you a verbal commitment or even a written commitment, I'm not sure how you will enforce that. Star 5, if you have a follow-up question on this, star 5. All right, let's go on. Oh, there is a question. Okay. This is New Jersey. Go ahead. Your follow-up question, please.
Yeah, thanks, Rajiv, for your community service.
Of course.
One follow-up question here is, how many days before we can file the EAD? Means, let's say if I have 10 months pending, in the
6
EAD,
months.
if I transfer my...
I believe it's 6 months. Double check that, but I believe it's 6 months.
Oh, 6 months. So, means in my case, first the transfer is supposed to happen. After that, once the transfer is over, then we need to make sure that six months before we can apply it, right?
Yes. So your wife's EAD
We cannot
and
file it
H4
concurrently.
extension should be filed no earlier than 6 months ahead of time.
So we cannot make a request concurrently, right, Rajiv?
You can do it concurrently, but
Means
the problem is if there is time remaining on the EAD, they won't renew the EAD.
Okay, so we do want to apply it again basically, or they can start working, once 6 months are pending, something like that.
No. See, there are different kinds of employment authorizations now. When you have CPT, it's a different kind. When it's an OPT, it's a different kind. When it's STEM OPT, it's a different kind. When you have 485 EAD, it's a different kind. H4 EAD, does not allow you to continue working even if you have filed for an extension. You have to stop until the new EAD comes in. That's why people are filing lawsuits. The reason people are filing lawsuits is because
Okay.
government is trying to destroy this program by creating so many delays that you lose your job. Okay.
Yeah.
So yeah, I would recommend anybody whose H4EAD has been pending more than 6 months, take a deep breath and go ahead and file a lawsuit. Let's see what happens. Okay.
Yeah, sure, Rajiv.
Good luck.
Thank you so much.
You're welcome.
Thank you.
Bye.
Bye.
Okay, so the last question today from exec transfer. This is the gentleman or the lady who has L1A EADAP pending, and they asked us whether this was an L1A, sorry, not EB1C. Okay, so if I quit or lose my job before I-140 approval, is there a problem? I'm on L1A to use portability. See, I'm a little confused about your question. I hope you're on the phone. You can clarify it for me. You see, if an EB1A holder loses their job and the employer has filed the case, you might have to refile, but EB1A you can refile premium processing, number one. Number two, there may be some argument that EB1A doesn't need a petitioner employer, so it should continue. I don't think there is any written policy on this, but you can certainly argue for it. Why would you not file EB1A premium processing? Okay. Then your last question is, if I move to another city, my family continues to stay in the same location, what is the best way to manage change of address? You must file your change of address. The family does not have to. Okay. That's simple. *5 if you have a follow-up question. *5. Okay. So we have about 19 more minutes. Anyone has any question, please press *5. Anyone has any question? Today is going to be an unusual day. Okay, only one question. All right. This one is from Texas. Yes, Texas, go ahead, please.
Hey, Rajiv. Yes, this is Kumar. So I have one more question. I moved from client A to client B within the same metropolitan boundary.
Sure.
So I haven't filed my amendment, but if I go for a visa stamping, do I need an amendment?
That's a complicated question. I'll clarify the law for you in a couple of sentences as best as I can. The regulations say anytime there is a substantial change in the job of an H-1B approved petition, they must file an amendment. So the law is any substantial change. The question is, what does substantial change mean? We know that if you move outside normal commuting distance, 40, 50, 60 miles, 50 is what the figure they give you, you have to file an amendment. That we know for sure. If you move to the same project in a different building, do you have to do an amendment? No, not if it is within 50 miles, if it's the same project, same job description, same actors involved, same parties involved. You shouldn't have to, you just have to post the LCA on the new premises. You do not have to do an amendment. But where the client changes, the project changes, the parties change, I think an amendment should be filed. Okay.
So even though it is in same
even if it is in the same
area,
building,
50 miles radius?
Even if it is in the same building, because
Okay.
I see it as a substantial change in the job. Okay. There might be other lawyers who would say, no, we don't need to. In my opinion, it should be filed. An amendment should be filed. Okay.
Oh, okay. Irrespective of whether I'm going for a visa stamping or not, doesn't matter.
You should get the amendment done, in my view. All right.
Okay. Okay.
Good luck.
Thank you.
You're welcome. Okay. We are answering the last question from back to Illinois. Yeah, Illinois, go ahead, please.
Hello, Rajiv sir, Nisar here. So, Rajiv sir, one question. To expedite my EAD, can I take help of your services? Is it possible?
I mean, we'll be happy to, but I think it's an unnecessary expenditure because if we get involved, then we have to go through a bunch of formalities. I am reluctant to take small interim cases, but if you have no other choice, we'll be happy to. But why don't you build a relationship with a local lawyer if you want somebody to go for an interview with you? Might as well make a deal with a local lawyer who can help you with this, and then also go for the interview with you. Okay.
Okay. Right.
Not that I'm not. I just think it'll be better for you. Okay.
Okay.
Good luck.
Thank you, sir.
You're welcome. Bye bye.
Yeah. Thank you. Bye.
Okay, guys, don't keep raising your hands. I asked you to raise your hand last time. Okay, this is the very, very last question we are going to do. Minnesota. Minnesota, go ahead, please.
Hi, Rajiv. This is Anuradha. And I had my question posted. I'm not sure if you're going to reach there, but this is a new question unrelated to what you've talked about.
That's okay. You can ask me any question.
Okay, thank you. So I came to the US to get an MBA, graduated in 2017, and my visa stamping was for the first university. I started working and my employer filed for my H-1B, went down the normal RFE and rejection route last year. So I went back
one
to
quick
school
interruption.
with
One quick interruption. Your lawyers should know that an MBA is not considered to be a professional degree. Okay. So if you have an MBA, unless it has a focus like marketing, information technology, international relations, and you're working in that field, an MBA is not considered to be a specific degree. Okay. So you won't get an H-1B.
So I had an...
Right.
Okay. Yeah, so one of the RFE components was specialty occupation, although my MBA is in healthcare and marketing.
Right. Your lawyers should know that.
Yeah, that was a completely waste of time and effort, actually. I think everything was done on a very, very wrong note there. Okay. But then I went back to the F1 status. This time I'm pursuing a master's in healthcare informatics.
Okay.
Which is, so this day one CPT, I'm assuming you already know that they let me work while I also go attend classes, and most of them are also online. So this program I started in August 2018, so it would have ideally ended in August 2020, but I took a semester break after this August. So now between September through December right now, I'm on semester break. That means I'm not working. And my CPT has been discontinued for this period, but then I'm planning to rejoin my program starting January. In the meantime, my visa stamping is valid through June 2020, but my I-20 is valid through December 2020. That's when the program is good for. So now I might consider traveling outside of US to India. How much am I in the line of fire?
You're probably not going to be able to make it back. The reason is, I'll tell you what the problem is. This is a very weird problem that the government has created. It's actually a lawsuit waiting to happen. They are going to get sued on this and they are going to lose. That's my prediction. What they've done is they have come back with a new interpretation these days that, according to them, the regulations say that you can have combined CPT OPT for only 1 year at one level of education. So if you have an MBA and you are doing another master's, the combined total for both programs or any one program can only be 1 year CPT OPT combined. So you're not coming back.
Okay.
Okay. Now, why is this wrong? Because if this is indeed the law, they should tell the international students' offices so the DSOs don't issue you a CPT. Why are they giving us CPT if this is illegal? Okay. Because we as students, we rely upon the DSO. The DSO works for USCIS. They've been trained by USCIS. If they are giving us the CPTs, why shouldn't we take them? So I think, like I said, this is a lawsuit waiting to happen, but this is all because of the jackasses in the White House, Trump and Miller, who are creating all these problems. Illegally, they are creating these problems because this is beyond their authority.
I mean, they know that there are people doing this and they're still letting it happen.
Yep.
So it's obviously a millibucket of everyone.
Right. So basically, if you go outside, ma'am, you're not coming back. I can pretty much tell you that. If this issue comes up, of course, if they don't notice it at the border and they just let it slide, you'll be fine. But if they are really awake and vigilant, they will ask you questions about this, and then you have a problem.
And so even if my visa stamp gets expires in June.
Same answer. Because working beyond 1 year CPT OPT combined at any one educational level is a violation of student status. The visa doesn't mean anything.
Okay.
Okay.
All right. Yeah. Thank you so much.
You're welcome, and good luck. You guys, good talking with all of you.
Yeah.
And I'll see you again in 2 weeks. Thank you very much for letting us be of assistance. It's always a pleasure speaking with everyone. Take care. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.